Rashmi, you can begin.
Yes, ma'am. Okay. A very good afternoon, everyone. I once again feel it an immense pleasure to welcome all the dignitaries and participants to the third session scheduled for today. It is more of an honor than a privilege that I got the opportunity to introduce Ms. Jaina Kothari, Senior Advocate practicing in the Supreme Court of India. Ma'am is also the co-founder of the Executive Director of Center for Law and Policy Research, that is the CLPR. She graduated from the University Law College, Bengaluru in the year 1999 with a BA LLB degree and has completed postgraduate studies in civil law at the University of Oxford in 2000. Her research and interests include constitutional law, gender and sexuality law, disability rights, and discrimination law. She has appeared as a counsel before the Supreme Court in many landmark cases. To name a few, the constitutionality of Section 377 of IPC and the independent thoughts case. She has authored a book titled The Future of Disability Law in India, which was published by the Oxford University and has made several other publications. She has taught in the University Law College, Bengaluru, as well as the National Law School of India, University, Bengaluru. In 2008, she was awarded the Wrangler D.C. Paute Fellowship in the University of Cambridge. She is also the recipient of the National Child Rights Fellowship 2010, awarded by the Child Rights and New Cry organization. Presently, she is the syndicate member of the Karnataka State Law University, Hubballi. I extend a very warm welcome to you for this session, ma'am. I would also like to welcome all the dignitaries and the Vice Chancellor of Karnataka State Law University. I also extend a warm welcome to the Registrar, Dean Faculty of Law, Registrar Evaluation of Karnataka State Law University, as well as the Director of the Faculty Development Program on Law and the Vulnerable. Now, may I request Ms. Jaina Kothari to kindly enlighten us. Please, ma'am.
Yeah. Thank you. Thank you, first of all, to KSLU, Dr. Ratna Baramgowder, for inviting me. It is really an honor to be part of your faculty interactive sessions. And I do hope that this panel and this session is as interactive and engaging so that we can have more of a discussion and have lots of people also being able to ask questions and raise some issues. So today, the entire day is on looking at vulnerable groups. And I know that the previous session has been on reservation and reservation policy. My talk today is really looking at caste, how caste caste is a vulnerable group, and how do we look at caste discrimination in India? What is happening? Are there laws to address it? And if not, are these laws being implemented? And if not, then what are the challenges? That's my attempt today. So let me just give you a brief introduction initially on caste and discrimination. I think caste is not a new issue in India. The issue of caste-based discrimination has been there in India from hundreds of years, from centuries, and that is why it was such an important issue to be included in our constitution at the time of the framing of the constitution as well. So we have several articles on prohibition of caste-based discrimination in our constitution, and some of them are Article 15. Article 15 specifically says that any discrimination on the basis of caste, among other categories like sex and place of birth and race, etc. But caste is a category for prohibition of discrimination under Article 15 of the Constitution. Article 16 provides for reservations in public employment and public education on the basis of, for scheduled caste and scheduled tribe persons. Article 17 of the Constitution prohibits untouchability, which is related to caste. So caste is a core category and group for that experiences discrimination in very, very serious ways. Sometimes, often what happens is that, because it is so ingrained in our constitution, we kind of don't really bother too much about caste-based, about learning or kind of following up on caste-based discrimination. I know that Even when we studied constitutional law, we in our 5-year law degree, caste and caste discrimination really was not a subject. I mean, it was just there, part of our constitutional law curriculum, but there was never really a focus on it. So I think it is really useful that today KSLU has focused on it and is part of the different vulnerable groups that and is part of this discussion. So I think, first of all, that is actually a huge acknowledgement, that KSLU is acknowledging that the importance of caste-based discrimination and such laws. So apart from the constitution, and I know that one issue on reservation was already done this morning, so I won't go into that, but I will try and focus on caste discrimination legislations in our country and which are those. I would just like to outline some of those. So we have really three main caste discrimination laws. The first is the Prohibition of Civil Rights Act, commonly known as the PCRA in 1955. The second is the SC/ST Prevention of Atrocities Act, which was enacted in 1989. And then we have the Prohibition of Employment of Manual Scavengers and the Rehabilitation Act, which is a fairly new legislation enacted in 2013. So these are the three core central legislations enacted to address caste-based discrimination, and I will outline how they do that and whether they are implemented or not. But there are a few state specific caste discrimination laws as well. I won't go into them, but I think it's important that I just at least put them on the table. And those are Devdasi prohibition laws. 4 states, Karnataka, Tamil Nadu, Andhra Pradesh, and Maharashtra, were states where Devdasi, the incidence of Devdasi dedication has been extremely prevalent. Even till date, it is still prevalent. Devdasi dedication is where women are dedicated to temples as Devdasis, but this is connected to caste groups, and therefore Devdasi prohibition laws are caste-based legislations which are addressed to prohibit caste-based practices which are discriminatory and exploitory of women, and so this also Devdasi prohibition laws also should be taken into the basket of caste discrimination laws. So I just wanted to highlight those, though I won't be going into these legislations for this talk. Okay, so let me go into 3 of the legislations one by one. First, I will talk about the PCRA. So the PCRA, the Prohibition of Civil Rights Act, was one of our first legislations enacted quite soon, almost immediately after our constitution was signed. And this was in 1955. And earlier, when it was enacted, it was not known as the PCRA, but it was called the Untouchability Offences Act. And it was named as the Prohibition of Civil Rights Act only in 1972. And like its previous name, the Untouchability Offences Act, the core, the main issue in this legislation, I mean, I don't even know whether many of us, I certainly hadn't read this until I started working on caste-based discrimination. And I think it's important that we all go back, when we get the chance to go back and read the law. It is an extremely, I would say, progressive and far-reaching legislation. And I would term it as perhaps, we don't have an anti-discrimination or an equality law in India, but I would say that perhaps the PCRA was one of our first equality legislations. And why do I say that? I say that because the PCRA prohibited any kind of untouchability and any form of conduct relating to untouchability. The curious thing, however, under the PCRA is that though the entire law is relating to prohibiting any kind of discrimination based on untouchability, nowhere is the term untouchability defined. And this is a curious issue, isn't it? Because we have Article 17 in the Constitution, which prohibits untouchability. It's a fundamental right that untouchability should not be practiced. We have an entire legislation prohibiting acts of untouchability, but untouchability is not defined. And you can say that it's both, there are pros and cons of it. The advantage is that you can have a broader understanding of untouchability, and untouchability is is understood as a broader social practice, which is not restricted to only avoiding physical contact or touch, but we need to understand untouchability as a broader social context, which includes any adverse treatment based on a person's membership of a certain social group or a caste group. So, for example, let me give you an example. A limited form of understanding untouchability would be the kind of caste-based practices we see happening in many parts of our country even today, where there are some places which have the two glass practice, where persons from certain caste groups, untouchable, caste groups which are considered untouchable, cannot use the same glasses or utensils for their food or tea and coffee. Practices of untouchability where a person is not allowed to walk or be in close contact with people from upper caste. But those are very traditional views. But a broader view of untouchability would mean even practices of social boycott, where you don't interact or you completely stop all interaction, whether it is social interaction, personal interaction, business interaction with people based on their caste groups. And that is a larger form of untouchability, which we would term as boycott, social boycott or segregation. And these practices have been addressed in this legislation, which was a 1955 legislation. So what the PCRA does is that it outlines a large number of practices of untouchability and prohibits them, and they are also made into criminal offenses. So these practices are criminal offenses and which can be punished by both penalty and also punishment. And some of those practices are preventing people based on their caste from entering temples or religious places, bathing in public tanks, entering any shop, restaurants, or any public place, prohibiting them in residential premises. We see a lot of that, where landlords are not giving places on rent based on caste, prohibiting entry into public institutions like hospitals, dispensaries, educational institutions, refusing to sell goods or services, compelling someone to carry out caste-based discriminatory occupations like scavenging, etc. So, all of these acts are addressed under the PCRA, and carrying out any of these acts against a person based on their caste group would amount to practicing untouchability, and these would be criminal offenses. It also provides for fines to be imposed, and there are obligations on state authorities to provide facilities to ensure that these kinds of acts of untouchability are not taking place. But today we are in 2020 and it's almost 70 years, and the PCRA is barely implemented. Its implementation is severely lacking. One of the reasons is that there is another stronger legislation, which is the SC/ST Prevention of Atrocities Act, which I will talk about, So as soon as these kind of more rigorous and stronger criminal legislation was enacted, the enforcement of this law has kind of completely diminished. So that's one reason. I think the other reason is that the punishment and penalty is quite minor. So a person actually going to the police and registering a complaint, the police also kind of taking action onto such complaints when the punishment is very minor is kind of, there's really no incentive, and so therefore its enforcement is very weak. And I would also say that because it's a criminal offense, which should actually be these should be civil wrongs, and there should be perhaps compensation or monetary costs, and perhaps that would lead to better enforcement. But the way it is now is that these are all criminal offenses, and in practice, really, we know how hard it is to go to the police station, register a criminal case, register an FIR, follow it through. So, though the acts of untouchability or social boycott haven't stopped, in fact, they're increasing, I think the implementation of this law has severely kind of diminished. There's no seriousness on implementing this law. So it's really like a dead legislation, I would say, which is unfortunate. It's completely become a dead legislation. I would like to now move on to the second legislation, which is the more stronger and to some extent a better implemented legislation, which is the SC/ST Prevention of Atrocities Act. This legislation was enacted in 1989, and it was enacted because it was felt that the PCRA was not enough. There were more instances of serious violence against persons from SC/ST communities, and the instances of violence were extremely gruesome. There were instances in the 70s and early 80s of massacres, large community-based massacres where it was almost where entire kind of villages based on people based on a certain caste were massacred, and these were caste-based crimes, and therefore this the Prevention of SC/ST Prevention of Atrocities Act was enacted in 1989. And what this law did is that it included a whole range of acts which were termed as atrocities or serious criminal offenses with punishments. And so it is for the first time that the term atrocities was coined for caste-based criminal offenses under the SC/ST Prevention of Atrocities Act. And of course, there were many offenses that were, of course, these were also offenses that could be there within our IPC, but there were other acts which were not in the IPC, but were particularly caste-based acts, which were termed as criminal offenses or atrocities, and these were included within within this legislation. So while it includes acts of killing, assault, physical violence, it also includes caste-based conduct, like compelling a person to pick up carcasses which are definitely associated with caste, with certain caste groups, carrying out humiliatory conduct or humiliatory acts like shaving a person's hair, shaving their mustache, which were practiced as caste-based offenses, to remind someone of their caste. And so all of these acts, were included as atrocities. And very importantly, this law was amended in 2015. It was amended quite substantially to include a whole range of acts as atrocities. And many of these included gender-based crimes, such as Devdasi dedication, which was also included as an atrocity, sexual assault against a woman who is from an SC/ST background, and this was given an aggravated punishment, which is much more than the punishment given to rape under the IPC. So parading or denuding, disrobing a woman from a scheduled caste or a scheduled tribe background. This was also included. So many other acts were included as atrocities by the 2015 amendment. Now, the SC/ST Prevention of Atrocities Act is not just a criminal law which makes certain caste-based crimes, caste-based discriminatory conduct as crimes or atrocities. The Act has a whole range of positive obligations on the state, which is meant to, which have been provided to ensure that there is some implementation of the law. And some of these include requirement of setting up special courts and exclusive special courts. So that means that exclusive special courts are to be set up where only offenses under the Prevention of Atrocities Act are taken up. And why is that? It is to ensure that the trial of those offenses are taken up in a short, quick, timely manner. In fact, it says that within 60 days, as far as possible, the entire trial should be completed. But we know that this never happens. Exclusive special courts are to be set up. Special courts are to be set up. And the government has to ensure that there are certain areas which are demarcated as atrocity prone areas where there is an increased level of violence against on the basis of caste. And not only that, there is a requirement that as soon as there is an atrocity and an FIR is registered, there have to be put in place rehabilitation measures. So the victim or the victim's family is to be provided victim compensation, other forms of rehabilitation, medical expenses, travel expenses for taking up the case and coming to court, going to the police station. In many cases, compensation in forms of cash relief and land or a compensatory job in the government. Witness protection measures are there in this law. And one interesting point is that as we take up issues of witness protection in criminal law, we fail to recognize that this law already has provisions where the court can put into place witness protection measures so that witnesses are not threatened or harmed and are in fact given the protection and enabled to come to court and testify in cases of caste-based atrocities. Then there is also a requirement that there should be vigilance and monitoring committees at the district level so that caste-based offenses are monitored and steps are taken for their prevention. But despite all of this, despite such an elaborate legislation with so many provisions for monitoring and rehabilitation and ensuring that the investigation and the prosecution of these crimes take place in a serious manner, the implementation is a huge problem. While it is certainly implemented better than the PCRA, we find that the only implementation is that the FIR is registered under the SC/ST Act and some offenses are included. But if we look at other measures, victim compensation, timely completion of the investigation, timely completion of the trial, setting up of the exclusive special courts, all of this is completely lacking. And I can just give an example from Karnataka. The government is supposed to file annual reports to the annual reports reporting the work and monitoring on the law. The last annual report under this act that has been prepared by the Karnataka government is of the year 2016. So it's been 5 years already, and there's been no annual report. We don't have adequate number of exclusive special courts in Karnataka. Atrocity-prone areas are not identified and not reviewed. Strangely, the areas which are deemed to be atrocity-prone areas, which show that there are more crimes against SC/ST persons, those are not the areas where there are exclusive special courts set up. Exclusive special courts are set up in other districts where there aren't too many crimes against SC/ST persons. So, this shows that there is no thought or any proper process in place to ensure that this act is ultimately implemented. Persons are not given compensation at different stages of the trial. So that is lacking. And finally, we have to look at the rate of conviction and how the crimes are really being tackled and how the trial proceeds. And if you see the conviction rates, it's extremely problematic and very, very dismal. In fact, there were news reports that as of last year, the conviction rates of cases under the SC/ST Act in Karnataka was 0%. So not a single case which completed trial led to any convictions, and all of them, there were acquittals in all. So in a particular year, I think it was 2018 or 19. So this shows really the sad state of affairs, and there is a lot to be done for implementation of this legislation in a serious way. One of the other reasons why also implementation of this law is not is not that strong is also that the law has been diluted in many ways, sometimes often by the courts. So there are a lot of judgments which kind of dilute the implementation of the law and make it less effective. So many of you might have followed that recently the Supreme Court in the Kashinath Mahajan case last year, the court, which was a case of anticipatory bail, and the Supreme Court in fact went to the extent of making an observation that the SC/ST Prevention of Atrocities Act is misused, and that made a recommendation that in all cases FIR should be registered only after a certain inquiry is made. And that created, there was a lot of criticism of the Supreme Court after that judgment. And then the Supreme Court, in a review of that judgment, in fact, gave another judgment which said that yes, there was no basis to say that there was any, it revoked its previous findings and said there was no basis to say that the act was being misused, and in fact reiterated that the act can be proceeded, complaints could be registered, and there was no need for further for any preliminary investigation to be done because there was no basis to find any misuse of the law. So some of these findings by courts create an impression that the law is being misused, when in fact the reality, if we see the empirical data and we find, when we look at the actual number of when we look at the conviction rates, we actually find that the conviction rates are so low that there's no legal basis to really say that this act is being misused. In fact, it shows that the act is not being implemented effectively. Some of the other findings of the courts have also been problematic. So there have been a lot of judgments of different high courts where some high courts have held that this act can only be used where the SC/ST persons are Hindus and not otherwise. And this also is slightly problematic because we do know that even if persons from SC/ST communities have changed their religion from, though caste is prevalent in the Hindu religion, and often when persons change their religion to other religions like Christianity or Islam, the caste continues. Their caste-based stigma that the communities face and that people face continues. There are Christian Dalits, there are Muslim Dalits who continue to face discrimination and harassment and forms of caste-based violence. But, findings given by the court to say that the POA Act would not apply unless you're Hindu would therefore limit the scope of this legislation. There are also judgments where cases of sexual assault or rape against Dalit women have been filed, And in those cases, the courts have held that the prosecution needs to prove that the accused who committed the crime did it due to caste prejudice. Now, that's a very difficult obligation. Even if the woman or the victim is of a scheduled caste or scheduled tribe, and that is not disputed, to put the additional obligation on the prosecution to say that you have to prove that the accused knew the caste of the victim and committed the act as a form of caste prejudice. Now, how are we going to prove that? How is the prosecution ever going to prove that? So, these kind of hurdles which have been put by courts on decisions, on cases under the SC/ST Prevention of Atrocities Act make conviction even more difficult, and therefore kind of dilute or make it very, very difficult to implement the act. So these are some of the challenges that I wanted to also highlight. And finally, I'd like to look at the last legislation that I wanted to cover in my talk, and that is the Manual Scavenging Prohibition Act. So this is called PEMSRA, this is the short form, Prohibition of Employment as Manual Scavengers and their Rehabilitation Act. Now, this is a fairly recent legislation. It's a 2013 legislation. But I'd like to, and this is also a caste based an anti-discrimination law. It's a caste-based legislation because it aims to eradicate or prohibit the practice of manual scavenging. And why do I call it an anti-caste law? Because manual scavenging is a practice that is deeply tied to caste. It has been traditionally a practice undertaken by members of scheduled caste, scheduled tribe persons, particularly women, and it includes cleaning human waste from insanitary latrines. It is a practice that has continued in families for generations of certain castes, and the practice also includes untouchability and social stigma that members of scheduled castes experience due to their carrying on of this practice. So therefore, I would say that this law is an important law if we want to understand caste vulnerability. What is interesting about the law is that this is a 2013 act. It replaces an earlier act, which was a 1993 legislation. The 93 legislation was called the Employment of Manual Scavengers and Construction of Dry Latrines Prohibition Act. And now we have the 2013 law, which is actually titled as a Prohibition of Employment of as Manual Scavengers and the Rehabilitation Act. Now, what is very interesting about this law is that though manual scavenging is a practice that is so deeply tied to caste, the 2013 or the 1993 Act nowhere mention caste anywhere, and that I think is quite shocking, that caste is not at all mentioned. So the law is kind of, is portrayed or is seen as a law that just seeks to prohibit the practice of manual scavenging, but there is no inclusion in the law that manual scavenging is a practice that is tied to caste and families of certain scheduled castes, and it is kind of this exclusion of a mention of caste is almost as a way of sanitizing the law itself. But we should not forget that this is a caste-based practice, and therefore there is a requirement to prohibit such practices. So what does, I'll quickly kind of take you through the law. So what does the 2013 legislation do? So the 2013 legislation defines what are insanitary latrines. It says that insanitary latrines are latrines or toilets which require human excreta or human waste to be cleaned manually, and it includes even any kind of insanitary latrines, which could be drains, pits, etc. Basically, any latrines which require waste to be handled manually and which are not so that is how insanitary latrines are defined. It defines manual scavengers as persons who are engaged by any person. It could be a private person or local authorities or a contractor for manually cleaning an insanitary latrine. Some of the provisions of the law, I mean, while it does prohibit manual scavenging in all forms, there are many positive obligations on local authorities. And some of these positive obligations are that local authorities have to carry out surveys of insanitary latrines within their jurisdiction, publish a list of such insanitary latrines, take action against occupiers, that is, persons in whose occupation those insanitary latrines are there, and ensure that they remove them. If they don't remove it, then the local authority can actually demolish or destroy those insanitary latrines, because the point of that is, as long as insanitary latrines are there, they will require manual scavenging. And so there is an obligation on local authorities to actually make a survey, investigate, and take steps to remove insanitary latrines wherever they may be. There's a prohibition that no person will construct an insanitary latrine or employ anyone directly or indirectly through contract or in any manner to as a manual scavenger. And if anyone does that, it would be a criminal offense, and there are punishments and fines. Any contracts for manual scavenging also amount to criminal offenses, and punishments are imposed. There's an obligation that there's a prohibition on any engagement or employment of any person for cleaning even other implements such as sewers or septic tanks, and there are higher punishments for that as well. I mean, we see that even today, even in big cities where you may say, okay, sanitary latrines are not so obvious, but other forms, apartment complexes have septic tanks, buildings, larger buildings have septic tanks or sewers, and any manual cleaning of those as well would amount to manual scavenging, which is prohibited. On the rehabilitation part, what does the law say? So the law, in fact, puts an obligation that all persons who are engaged in manual scavenging, they have to be rehabilitated and moved out of this occupation and rehabilitated to other occupations. And so this involves an obligation on the municipality or local authorities to actually conduct a survey to identify people who are engaged in manual scavenging in their jurisdiction. They have to publish a list. They can also invite any member to actually say that, yes, I am engaged in manual scavenging, so I also want to be in this list. And after making an inquiry and publishing this list, and getting objections, if any, or getting additional names from persons, all persons who've been engaged as manual scavengers should be given an ID card. They should be given, and there are a lot of measures that they have to be provided so that they are able to get out of the practice of manual scavenging and do other forms of occupation. And this includes providing them cash assistance, includes providing scholarships for their children, providing residential sites or plots, or financial assistance for building a house, providing vocational training and paying for that vocational training, providing loans and subsidies if they want to take up any other business or any other employment activity. Now, the problem is that none of these things are being implemented. The identification of insanitary latrines and demolition is not being done. Identification of persons engaged in manual scavenging is not done. And even providing them ID cards, providing them all these rehabilitation measures are not being provided. Unfortunately, we see there is so much money kept aside for such rehabilitation schemes, but this money is not spent. Persons who were earlier engaged in manual scavenging, when they seek loans, especially women who seek loans for starting their own businesses, are not provided loans by the agencies who have actually been set up to provide loans for manual scavengers. So we see that none of these rehabilitation measures are really being carried out. And I just want to now go on to a few judgments and how they have interpreted the law, and if they have, especially some progressive judgments. One big important judgment was that of the Supreme Court in 2014 in the case of Safai Karmachari Andolan versus Union of India. This was a judgment in a case which was filed much before the 2013 Act. It was filed to implement the previous 1993 law. And then it kind of continued when the 2013 Act came as well. And in this judgment, the Supreme Court held that manual scavenging is a violation of a person's fundamental rights and human dignity. And it required that this law be strictly implemented and gave directions to the state government and union territories to implement the law. And in fact, this case was filed when there were a lot of deaths of manual scavengers, and the court laid down that every family where a manual scavenger has died due to manual scavenging, a compensation of 10 lakhs would be given to their families. And this is what is being implemented even now, that at least a compensation of 10 lakhs is given. But, we look at the law only when people are dying due to manual scavenging. What happens to persons who are engaged in manual scavenging and are not being able to be rehabilitated, and no action is taken to ensure that the practice is not carried on? So in this regard, I'd like to refer to one very important judgment of Karnataka High Court, which unfortunately was overturned by a division bench. So this was in 2016, there was a judgment given by Justice Narayan Swamy in state of Karnataka versus Rama Devi. And here, of course, the 10 lakhs compensation was given, but the court actually held that even it's not just manual scavengers who are engaged in cleaning unsanitary latrines, but even persons engaged as Paura Karmikaras or sweepers or cleaners in the municipality, they also have to be recognized as manual scavengers, and all benefits have to be extended to them. I'd like to go on to a few other decisions. There was, in cases, we find that even complaints, criminal complaints, in case of manual scavenging, the implementation is extremely weak. Only when someone dies due to, cleaning a septic tank or cleaning a manhole, then in those cases, a case is registered and the 10 lakhs compensation is given. But in other instances, the follow-up and prosecution is extremely weak. And in one case where there was a complaint filed, this was again a Karnataka High Court judgment, a complaint was filed by a third party on an offense under the Act. The Karnataka High Court held that if a complaint is filed, an FIR has to be registered, even if the complaint does not have too many details or particulars of the manual scavenging. It is mandatory on the police to register the FIR and conduct investigation. And in such an FIR, provisions of the SC/ST Act can also be raised and should be included. Now, this Act also has similar monitoring requirements. It has requirements that vigilance and monitoring committee should be established at the state level, central level, and there's a national commission for Safai Karmacharis. But the activity of these commissions are highly suspect, and there isn't much vigilance and monitoring done. So I think even this shows that though this is a fairly new legislation, the implementation of this law is also highly wanting. It's not effective, and in fact, there is also a PIL in the Karnataka High Court seeking the proper implementation of this law. So I'd like to, I think it's been about 30-40 minutes. I think I'll end here. I've tried to give a broad overview of the different legislations on caste, which highlight the vulnerability that that persons from scheduled caste, scheduled tribes face. And even today, we find that discrimination against persons on the basis of caste has not ended, certainly. And there is more awareness about it, but that awareness has not reached the implementation of legislation. And so that is a real concern, and we need to really put more of an emphasis on these laws and put pressure on state authorities and the police to ensure that these laws are implemented. Thank you. I'm happy to take questions or any comments.
Yes, ma'am. Thank you so much, ma'am, for an enriching session. There are indeed a few questions raised by the participants. I request Mr. Girish Casey, Assistant Professor of KSLU's Law School, to kindly raise the questions on behalf of the participants.
Thank you. Thank you very much, madam. Your presentation was very informative, and you have explained in a lucid manner the provisions of caste discrimination legislations and the approach of judiciary in interpreting the provisions of these legislations. Madam, most of the questions which are raised by the participants have been answered during your presentation itself. Still, there are few questions, madam. Even when we look into the NCRB data, the caste discrimination continues to exist in spite of many legislations. What needs to be done to prevent atrocities against SC/ST? So this is the question, madam. In spite of many legislation, caste discrimination continues to exist. What needs to be done to prevent atrocities?
Yeah, now that's a tough question, right? We how to prevent caste discrimination. That is a question that has been gripping our country from the time we've got our constitution, and that can only happen if there is a serious awareness created that caste-based discrimination is wrong. It's a kind of it is a violation of principles of equality and dignity of persons, and that all human beings are equal, irrespective of their caste. But these are not. This requires a change in our social behavior, and some of these laws are just to ensure that this does not happen. Laws can only help change social behavior, right? Because it prohibits certain kinds of actions, but socially we have to address these things as a society. How do we address it? It requires education. Today our children, let me ask you a question. Today when we are in school, do children learn about caste discrimination in school? No, they don't. It should be taught, right? In small children, even in first, second, third, fourth standard, it should be there, that they should be taught that caste-based discrimination is wrong, so that when they're growing up, they grow up with the right values of equality. But today in our school and in our school education curriculum, we don't have anything about caste discrimination. We don't even have anything about gender discrimination, that treating. These issues of discrimination are very complicated issues. You can't just say it should not be there. We have to ensure that the importance of equality that caste discrimination should not be there is there in every area of our lives, especially in education, where it would have the most impact.
Another question raised by a participant. The participant is of the view that the position of Prevention of Atrocities Act is like a tiger not having teeth or nails. What is your view on this?
No, I wouldn't say that. I wouldn't say that. because if you see the Prohibition of the Prevention of Atrocities Act is quite a strong law. And there are strong punishments, imposed, prescribed for the atrocities. So it is a quite a strong law. But the problem why it is not effective, perhaps what the participant is asking is that it's not having any teeth, is because it's not implemented, and we're not seeing ultimately. You may go and file and register an FIR, but ultimately it does not lead into conviction, is because our investigation system with the police, our prosecution, our courts, all these branches, on one level you have the police which does the investigation, then you have the prosecutors, and then you have the court. At every level, I think there are serious problems with our criminal justice system. They don't take the Atrocities Act very seriously. So prosecution is not done effectively. Investigation is not done properly. Today we can see even in the I'll just give an example in the Tamil Nadu case, which got a fair amount of news, where there was the case of the intercaste marriage, where Shankar and Kaushalya, where the she had married a boy from the Dalit community, and he was killed it was no secret that he was killed by her parents on the basis of caste. But ultimately, even the Madras High Court has acquitted her parents and only convicted the hired assailants who were hired to kill. And the her parents who were, or her father who had masterminded this, has been acquitted. So our courts, our prosecution system, our police, all of these need to be sensitized on caste. And that's, if they're not, then it remains just a paper tiger and without any teeth.
Yeah, you have answered the question in connection with the same question. Like, there was also a question raised by another participant. Police officials are not ready to register a case under special legislation in many cases. Even if case is registered, accused will not be punished due to lack of evidence.
Yeah.
Circumstances, how to protect the interest of SCST against caste discrimination?
Yeah, so this is a big problem. Police don't register cases. They will just register, and I saw one of the persons had raised in the chat, they will just register it as an IPC general offense. They will not invoke provisions of the SCST Act, even though it may be very clearly a caste motivated crime. So that is very difficult. And unless you have influence, or you have some way to be strong with you're able to take a lawyer who will argue for you and get your case registered, it's very difficult. In cases where even if the SCST Act sections are invoked, the investigation is done in such a shoddy way that ultimately it will lead to an acquittal. And then there are so many hurdles on top of that. Our judiciary in their judgments puts hurdles that prosecution has to prove that the accused was aware of the caste of the victim. How are you able to prove all that? So all this is a huge problem. It goes to, we need a reform of our criminal justice system. How do we ensure that police are strong on caste? They don't just have to be sensitive, they have to be, police have to see their role as ensuring that they are there to protect the victims. They are not there to harass victims. That is how unfortunately how our criminal justice system has become. So it needs complete overhauling. Our police need a lot of training and sensitization on this. So yes, these are serious concerns.
And ma'am, one last question with your permission. So that is relating to implementation, which you have already explained in your presentation, the challenges which are there for effective implementation. A participant asks a question: what measures can be adopted to have effective implementation of SCST Atrocity Act and to prevent its misuse? What measures can be adopted so that it can be effectively implemented and the misuse can be prevented?
Yeah. See, effective implementation, of course, is to implement the provisions of the Act both in letter and spirit in a serious manner, which means that if cases are registered, if complaints are filed, cases should be registered. There should be proper investigation. There should be all the compensation, rehabilitation measures given in the court. They should do it in a way that the trial is finished in a short time bound manner. All this, if this is done, it will ensure that victims are protected. All of this will ensure that it will lead, if it's a genuine case, it will lead to a conviction, and in a time bound manner. Now there is a concern, is the act misused? Now, and how do we ensure that misuse is prevented? Now, if any law, I mean, every law is open to misuse. I don't think it is only the SC/ST Prevention of Atrocities Act. Any law is open to misuse, and people will always find a way to misuse a legislation. Today, we are finding even the Dishonor of Checks, Negotiable Instruments Act being misused, right? The Negotiable Instruments Act is a benign law. I mean, it is just to prevent, check dishonor, etc. Even that is misused sometimes. So any legislation can certainly be misused. But if you want to ensure that there is no misuse, again, I think we have to ensure that our police, our courts, our prosecution implement the law properly. If someone has filed a false complaint, then I'm sure the police, with their investigation, can ensure that this complaint should not be proceeded with, or other steps. It will result in an acquittal. Even before acquittal, if it is a false complaint and investigation does not reveal that, certainly a B report, etc., can be filed, or charge sheet needn't include some of these offenses. But the problem lies when there is an assumption made that the act is misused. So every time someone even goes to file a complaint under the SC/ST Act, everyone, the police, prosecution, courts, the mindset is that this is a false complaint, this is a false complaint. So let us not start with with a presumption of misuse. We should go forward with the focus on implementation. If we focus on implementation, automatically, if there are any misuse, I'm sure that will be addressed.
Thank you very much for answering the question.
Thank you, sir. And thank you, ma'am, for sharing your valuable thoughts with us today. Now, may I request Professor Dr. Ratna R. Bharamgowdar, Director of the FDP in the Law and Vulnerable, to kindly speak a few words.
A very good afternoon to all the participants. I heartily thank Ms. Jaina Kotavi for delivering a very enriching and insightful talk. Today in this session, ma'am has emphasized that despite protective constitutional provisions and reform efforts, deep-rooted prejudices hold firm in the society even today. She further analyzed important specific legislations that aim to create equality and has observed that the caste system in India continues to have a strong impact on society, and those on the lower rungs still face marginalization, discrimination, and violence. And further, she has also highlighted some of the progressive judgments of the Supreme Court. Ma'am, our participants have been very immensely benefited by your scholarly presentation. On behalf of Karnataka State Law University, I express my heartfelt gratitude to you, ma'am. Thank you so much.
Thank you so much for inviting me. Thank you.
Thank you, ma'am.
Madam.
Thank you, ma'am. It is my honor and privilege at this moment to propose the vote of thanks.
Rashmi, just a minute.
Just a minute. BC sir wants to speak.
Oh, okay. No. I wanted to just thank. It was a very exhaustive presentation about strength and weakness of law. You have highlighted quite critically. Thank you very much. Our FDP participants will be beneficiaries of that.
Thank you, sir. Thank you.
Thank you, sir. Now at this juncture, it is my honor and privilege to propose the vote of thanks on behalf of the Karnataka State Law University. I take immense pleasure in extending my sincere thanks and gratitude to Ms. Jaina Kothari for her illuminating lecture on casteism as a means to vulnerability. Thank you, ma'am. I would also like to thank Professor Dr. P. Ishwar Bhatt, Honorable Vice Chancellor of Karnataka State Law University, for his vision and effort in organizing this program. Thank you, sir. I would like to extend my gratitude to Major Shidlingaya S. Hiremat, KAS, Registrar of Karnataka State Law University, for his support. I wholeheartedly thank Professor Dr. C.S. Patil, Dean Faculty of Law, Karnataka State Law University, for his constant support and guidance. Thank you, sir. I would also like to express my gratitude to Professor Dr. G.B. Patil for his valuable presence. Thank you, sir. And I also express my heartfelt gratitude to Professor Dr. Ratna R. Bharamgowda, Director, FDP in the Law and Vulnerable, and also the Professor of Law at KSLU's Law School. Thank you, ma'am. And last but not the least, I thank all the participants for their active participation for the session today. Now we adjourn for the day.